Please make a glance your lordship's order by annexure 1 on page 9, my your lordship grant. Your lordship, my lord, so far annexure 1 is concerned, your lordship please pass to an order with a direction to OP to comply your lordship's order within 8 weeks, my lord. Elapsed. That is annexure 1 on page 9, my lord.
Service. 3 weeks. 2 weeks after the.
This judgment is now with, set aside by Honorable Supreme Court.
No, then give it. Is it?
Yes, your lordship.
Show us. Then how the contempt lies?
Your lordship may give me next week, your lordship. I will.
Sir, the judgment has been set aside by the court.
Okay.
No, here. Matter you ascertain whether this judgment rendered in case of Narottam Roy
Yes, your lordship.
has been set aside by the Supreme Court.
And other cases which followed Narottam Nath at that time,
I will.
they were also, I feel,
You ascertain
if-
whether this
if at all
this
this
question also
no, this order you have
Just
challenged before the Supreme-
adjourn for a week.
What are we?
Yes. Certain.
Item number 2.
Second item, same thing, my lord. Second also same, my lord.
Yes. Let us see both.
Item 2.
My lord, item number 2. This is a very typical and delicate.
Your Lordship has the order on dated 30th January 2024.
The content.
My Lord,
The content matter.
content matter, my Lord.
Where is the operating portion of the
Operating
order,
code, my Lord, page 9,
Yes.
para 6, my Lord. Having Heart Land Council for the part, my Lord.
No, not the.
And para 7 is,
Where is the operating?
my Lord, para 7, in view of the above, since the matter is pending with the state government for consideration, this could direct the opposite parties state to take a decision on the aforesaid issue expeditiously as possible, preferably within.
What we have
My
done,
lord.
sir? Was it communicated to us?
Not- Yes, my Lord.
Where is the proof?
My
of
lord.
this? Proof of communication.
My Lord, communication on dated 23rd September 2024, my Lord. The association secretary communicated the mode of submission with grievance cell of the chief secretary
So
submitted
there is a seal.
personally, my Lord.
Here is a seal.
My Lord, the secretary personally submitted on grievance of the chief secretary, my Lord.
Sir, there must be a seal. Something is to be done.
My Lord, they have not given any. No, my Lord, they have not given any receipt, my Lord. Yes, my Lord.
Contempt.
My Lord.
The first principles of contempt is
Service
that
of notice,
that the LS contemners was communicated with the orders.
my Lord.
Despite having known the order, he has violated it.
Yes, my Lord, they have
So,
already
this
received.
thing is the communication is a very important factor that he was aware of this order.
My Lord,
Where is that?
my Lord, the petitioner not received any receipt from the
That
contemptor.
sent it by post.
My Lord, they have not sent the post, my Lord. Grievance, my lord. With the copy of the order, my lord. My lord. No, my lord. My lord, since there is a specific direction, state with the party, no specific direction was given to the petitioner, my lord, to serve the copy.
So I take it,
My
that
lord.
if a direction is passed on a department of transport, you make a service in the Department of Health. So it's a government. So you have already communicated.
My lord.
Very interesting. It's a contempt again, I'm saying.
Sir, you must know how it is communicated. Unless you find it, yes, it is not.
My lord. My lord.
Is it not?
Yes, my lord.
So, demonstrate.
Not a casual way of drafting and filing the contempt.
My lord, they don't have any receipt, my lord. They have not sent. Yes, my lord.
No.
Yes, my lord.
Thinking that if they are not giving the receipt, there must be some other mode of service.
My lord.
I have this, sir, but no receipt was granted. I am sending you again
My lord.
through this mode. Will you not? That gives them a defense. Do you
My-
understand?
My lord.
If they say it was not communicated, it was not there, it was there in some other cell, nothing of that kind. I was not communicated this order. Then
My-
how we can hold them responsible for contempt?
My lord, already registry also communicated the order, my lord.
Where is that? You are saying, but there should be.
Instruction for your- for your lordship.
What is
Obliged, my lord.
Item number 4.
My lord. My lord.
Item 4.
May I please your lordship. Item number 4, this is the fresh contempt, a matter regarding sanctioning of pension and other retirement dues. Operating person, my lord, judgment, last page 9.9, for page number 45, 46.
Page 53. Page 53.
Direction to consider the pay and advances along with service benefits as admissible under subgroup 2 and subgroup 4. Rule 91 of the Orissa Service.
Your Lordship may kindly see para 9 of the judgment. There is para 9. Your Lordship have observed that the petitioner is entitled to the duty, pay and allowance. Yes. And this is the order passed by the authorities immediately after the writ appeal. And this has been communicated to the petitioner. I have, Your Lordship may kindly.
That has been complied with.
Yes.
Yes.
So what remains here?
Communicated with this.
So it has been treated as on duty.
Yes.
What more?
That actual benefit, financial benefits, you will get, my lord, immediately. My lord. They have already, and if your lordship will see the memo down that last paragraph, it has been forwarded to Ghasiram Behra, junior clerk, the petition. It's communicated. And copy, sir.
It was just now I received the copy. I'll take instruction.
Nothing is there. There is only thing is that we have said they have taken a decision. Now, if you are still agree by it, then it's give you a fresh cause of action to do.
But now my client has retired from service. But now my client has retired from service. He has not received a single pie.
Oh, he will get it, sir. That was not a case here.
But
That case was that he has to resume the service.
yes.
And he was there. You wanted certain alliances is why the
No, he already retired.
That's
Already retired, sir.
by this time, sir, but assignment was delivered and they have taken a decision to give you.
Yes, that's true. But
That is the irony here. Here we have the fresh adjudications are made with deepest of respect and humility.
no, that's true.
We are simply whether there has been a conscious and willful or deliberate violation. And secondly, we have to see that the order is implemented. That's all. Nothing more than
But one line must have one line are there not let them take immediate decision
no,
regarding
that will
something.
not. That's beyond the contempt jurisdiction. That's beyond the contempt. Either it will be allowed or it will be dropped.
Yes, that's true. Yes.
Nothing more than in between nothing.
But may I next week let it come. I will take this.
Nothing.
What is the
Whatever he has done it, whether is the correct or wrong, that will be taken care of.
Item 5.
May I please, your lordship? Operative person, your lordship will see page 3, paragraph 7. That is your lordship's order. Page 48. Annexure 3 of the contempt provision, your lordship. That starts with in view of the efforts at discussion and file.
Yes, only
Clarification.
from the date of regularization.
Yes, my lord. Here the IDCO authorities have been added as party.
This communication.
My lord, the next annexure, page 50, annexure
No,
4.
that is the postal receipt.
My lord, postal receipt.
There is a proof of service. This is a proof of dispatch.
My lord, proof of discharge. Your lordship, I could follow your lordship. My lord. That is it by registered post means that
Here
is.
the
So what? Presumption under
My lord,
Process Act.
They
Then
have-
you have to show that you have prepaid, you have correctly.
My lord.
Presumption does not automatically. It's not.
No, I could follow your lordship's query. We'll see that now also
Well,
postal
let us
tracking
see
can
whether-
here the IDCO authorities have been added as parties,
So notice is
for whom my learned friend is
We have instruction to appear, my lords, for it. My lords. I will intimate them, my lords, by authority, my lords.
Which containers?
My lords, for IDCO chairman, OP1 and also.
And
OP1, 2, and 3. My learned friend is appearing,
My lords.
and for 4, 5, 6, 7, 8, I'll appear. For 4 to 8, I'll appear. 1, 2, 3, my learned friend will appear.
My
you have
lords.
received the copy.
Not received. I request
First
copy.
time it is
First time it has been posted today.
Then we are correcting the issues of service.
My lord.
Then the individual
my lord.
special notices. 2 weeks after. What are the
Item number 6.
May please your lordship see the GST cancellation losses and the losses passing the order. I pray for I ready to willing to pay other.
Item number 7.
Lord, that relates to RC cancellation, my lord. Related to RC cancellation. Obliged.
As I have quoted the order from page 3. The cooperative part is from para 5 at the bottom, the last para on page 3, my lords.
Three.
Yes, my lords.
In the petition.
I've quoted the order in the petition.
Where is the order? That has to be next. Where is the order? Oh, you are keeping it. You do not want that we should peruse it.
The time when it was filed, at that time there was some.
This system, sir, when you are filing a content application, you should annex the copy of the order which you allege to have been violated. Quoting in a paragraph will not do. It's a defective. Why the defect has not been pointed out?
I mean, we are allowed to quote because there is a some procedural way of indexing cost and all, and sometimes it shows the defect. That's why we quote the order, the entire order in the.
I have to look at the procedural aspect in this. What I know from the other.
Yes, I can understand. I know, man. Lordship was telling us.
I thought.
Lordship was telling us.
In the preamble, you should say what is the allegation, what is the violation.
But
in the prayer, you should also incorporate what is the violation.
The preamble, I have, in the first paragraph.
In the preamble, you have simply said that an application for initiation of a content against the opposite party for their willful and intentional disobedience and the non-observance compliance. This is not a complete one. They have to say that the application for contempt against the contender for violating the order dated such and such in this, then you say not complying or not considering or not disposing of within 3 months as directed, not giving a benefit as directed, all these things.
When I made out the violation in the first paragraph, it relates to cleaning and treating of untended pond and running.
I do not know the procedure. There, the rules prescribe that you'll have to, in short, the alleged content in the preamble, not in the paragraph.
No, in the preamble, first paragraph.
So this preamble is this. Preamble is
cost title, part of the cost title.
Above the cost title.
Yes.
You have not said so, simply say disobedience of this order. Wow, what is the nature of disobedience? You have to spell.
This is filed in 2016. What the Lordship is mentioning, that was incorporated in our rules later on, and we are asked to mention that in the preamble.
Actually, the prayer also that he should be punished for contempt, for violating these incidents.
May I place the order, my lords, the order of the Honorable High Court. Municipal corporation, because it's their duty to see that every, they are, no, not at all. Because earlier, 35 years back, every year they used to clean it twice or thrice. After that, they have stopped.
He will government. So there,
Lordship telling you.
there, direct the petitioner to serve the copy and file the affidavit of service on the receipt.
That's the service.
But here everything is to be done through department. Here the departments are not burdens.
That IA may be, it's not pressing the IA, it may be dropped. When IA is there for the change of the name, the incumbent is not pressed. Lordship will fix a date, my lords.
Once you file it,
Yeah, I'll file it within next week. Yes, I'll file in theater, date may be fixed. Say date may be fixed.
Item number 9.
May I please, Your Lordship, on behalf of my senior Lordship, this CMAPL for restoration of review petition, Lordship. On the last occasion, Lordship have
restoration of
review petition, Lordship. CMAPL, Lordship, filed for restoration of review.
when it was dismissed from the court.
Lordship, 26 June 2024, Lordship, for non-prosecution.
This is the order.
Lordship, Annexure 1, page number 6, Lordship. Order dated, Lordship, of 20 June 2024.
When the application is filed,
Lordship, 27 September 2024, Lordship.
That is delay and they have filed a petition for confirmation of delay.
that is filed on. On 14th
I-
December, 14th
October.
You have forgotten. Oh, you were not there. Your counterpart sitting by your side was there. You are there.
Only fair.
What is the ground? Why you could not appear on that day?
Lordship, due to oversight of the advocate, due to oversight, Lordship, missed the list. Paragraph 3, Lordship, I have clearly mentioned in the CMAPL, Lordship.
The father-in-law of the
Advocate,
Second for very much. Could not watch the list. So. Yes, sir.
If there was a bereavement in the family, and that bereavement is also very important. Who died?
Other.
No, he has no choice but to go there. Can he defy the rest of the life? Yes. This is an application for restoration. Any respectful expression is accepted. So it has to people achieve.
Time to
Or
obtain instruction.
contempt.
Contempt.
Order.
Order is
Our
annexed.
order or
Annexure one.
that is what I wanted.
When the order is complied with.
Why my brother's orders are not being complied with all the time?
Complied with.
Why?
It is complied with.
Within 3 months. Why you have not done it within 3 months, sir?
We have done it.
3 months.
Yes, sir. Order
And have you communicated to him? Have you communicated this order to him?
No, ma'am. I am not aware of. It is not communicated to me. No, I have taken. That's why I have filed the. Yes. Yes, madam. Now also document.
Pass the order, not communicate.
Whether it is communicated or not.
You have the extra copy?
Yes,
Give it. This is the contempt. This contempt. Friday.
Lord, this review is on a limited issue, my lords. So lordship should just
Review is always in a limited one.
yes,
Where is the order?
order, my lord, is at annexure. Yes,
Page. Give me a page.
that is page 62. It starts, but the order starts from page 65. So one page order. May I just place my
Yes.
lords.
Yes, 1 page order, 30 seconds.
Absolutely.
Yes.
Yes. Your lordships may come to annexure 8 at page 52, which was, my lord, what has been cited that since it has not been challenged, so the court didn't interfere on the earlier occasion. If your lordships would see that even though it was directed to stop the work, but it was more of a compliance order where I had to comply certain conditions. Lordships may come page 52 if you like.
No. There are two facets of the
Yes, my
One is
lord.
that order stopping the mining activities until further order
Yes.
is also there.
Yes.
So you have not challenged that particular order.
No, my
Then
lord,
it
I
says that
complied.
There is already a stoppage. Then
My lord,
the permission to run or continue running is preposterous.
my lord, I complied with the
Now it's a
requirements.
subsequent act, because in presently at that point of time, this was there and there was no compliance.
No,
from
that
your
was
side.
there, my lord. That I had submitted also as on that occasion also.
But it says that you can't.
My lord, the
Asking the petitioner, they have listed, while asking the petitioner to comply with the deficiencies as pointed out, he was asked to stop.
yes,
The petitioner did not challenge means that order is stopping the mining activity.
that portion of the order may be, my lord.
No, sir.
My lord, but then it is more
So-
of a compliance.
No compliance, then they will definitely take a fresh decision.
My lord, now
The
that
order does
since
not
that,
stand in the
my
way.
lord, that since that period is over, I have made an order.
That is why the court says that since the stoppage has already been done, at this stage, you have not challenged that order. So we will not permit you to continue because there is a stoppage order.
Right, my lord, to that extent. But there was another prayer in my writ petition, if your lordships would see, with the connected writ, to refund the advance royalty that I had paid for that period. That was also in the prayer. That has not been at all considered. So to that limited
So you
extent,
politely refuse. What is the law?
that if the implied refusal, but my lord, to that extent, if a liberty is given to me so that I can approach them for the refund, because I have not operated for that period. Because the royalty and everything is paid in advance. Also,
then what remains? Then maybe a
Lord, to that extent, my lord, I need the
What is the
permission.
basis? No, there cannot be a basis. Review, you know, very.
I understand, my lord. Subject, my lord, that is my only. Yes, my lord, in the paragraph. No, I have seen that, my lord. To that extent, I seek, my lord, if it can be, lord, reviewed, because he has not operated for that period and it was paid in advance.
The reason is given. The reason may not be appropriate, but the reason is given.
A reason.
For denial.
A plausible reason also, my lord.
What happened on that day?
Oh, who is the
and
record?
He was also not there.
No.
Mr. Ray was there, but
No,
because
Mr. Monobihari Ray
yes,
was there.
but my lord, because of his actually he's not well, so that's why he asked me to conduct this case after filing it.
Yes, thank you.
There is no difficulty.
My lord, that of course, as your lordship says, because your lordships were deciding the matter. I understand, my lord.
No, in one of the judge matter, we have taken a very serious note of it. That main petition is or the main argued by one counsel.
No, that is also the practice here also.
Another counsel.
No, my lord, that is the practice here also. The councils don't change. If the review is filed, it should not. No, that is the correct view. That is always because of his. No,
No, this is an application for review. This is not, sir, this review application is
Item number 13.
Wait, please, Your Lordship. Your Lordship, herein also.
Again review.
Yes, Your Lordship.
Now you just heard.
Yes, Your Lordship.
Show us.
Your Lordship, there is one fact that has not been brought to the notice of the court, that the opposite party number 6, by the time of disposal of the writ appeal, he had already retired.
So how it will change the character and
Your-
the nature of
Your
the
Lordship,
ultimate order?
I am here for a very limited consideration by Your Lordships, that there is one particular paragraph 9.13 by this bench, that the appellant is
9.13.
9.13 at page number 32,
Yes.
Your Lordship. Has taken note that Gayadhar Naik, being senior to the appellant, is entitled to the second post, and thereby the appellant has no right to claim the said post. So, Your Lordship, this is creating hindrance for me. He has now retired.
This is greatly.
Yes, Your Lordship. So now
This is greatly.
creating hindrance for me, Your Lordship.
Why?
Because
He is not senior to you.
he was senior to me. Now he has retired.
At the time of the judge.
Your Lordship, at the time of the judgment also he had retired. So that is what is my contention.
But you are claiming the post from the earlier date.
Your Lordship, now that he has retired, Your Lordship, and that yes, Your
What
Lordship.
remains?
But
Can it be given from a retrospective date?
Your Lordship, the permanent post was given effect with a retrospective date only.
This is the promotional post.
Yes, Your Lordship. It's a night watchman, so but the approval was done
Right to
retrospectively.
be considered for promotion is a vested right.
Yes.
But right to promotion is a vested right. You are claiming a right to promotion. Nobody can.
Your Lordship, our own.
What it is? No. No.
No, Your Lordship, but understand. But this one observation that we have no right at all, that is
That
the
observation will be there.
earlier also it was done retrospectively only. So that is what we had challenged ultimately.
The difficulty is, madam, now the promotion. Both of you are.
Your Lordship, now as I had been
I understand
yes,
that
Your
you
Lordship.
wanted only the monetary benefit that will be extended. Your pensionary or the scale of pension will be varied. Obviously.
Yes, Your Lordship. But I just wanted to be reinstated to the earlier post because I was continuing in that post. Subsequently, there was a retrospective application of an order and I was demoted.
You could have asked for in the main.
Yeah, Your Lordship, that we had asked for, but because
Start.
yes, Your Lordship, that is why I. No, Your Lordship, while filing of the writ appeal, Your Lordship, it was not there. After, Your Lordship, I was a night watchman. So that is what is my contention.
Why you did not argue as you are arguing now at the time of the appeal? Why you did not argue all those points?
Your Lordship, that has been a fault that has not been brought.
No.
No, Your Lordship, I didn't. The opposite party number 6 was also this thing.
Raise this point when you appeared before the appellate court.
Your Lordship, I agree. We had been instructed that the petitioner was not aware because the opposite party.
when you are taking after going through the documents, then you should have raised this point while you were arguing
Your Lordship,
for the appellate court.
yes, Your Lordship.
So
The
you were
fact.
arguing, you knew it that this is the point.
No, Your Lordship, that was not in the knowledge of the petitioner's knowledge, because opposite party number 6, Your Lordship, he was a party to the writ appeal.
You say that this is a new document which has come.
Yes, Your Lordship. That
You
he
wanted to rely on a new document in the review.
No, Your Lordship. What I am saying is, I'm not relying on any document, but it has come to my knowledge, Your Lordship, that the opposite party number 6, he had already retired.
So that pleading was not there. Can
Yes,
come under the apparent on the face of the record. I am just saying. If the record is silent, then what is the wrong which the judge has committed?
Your Lordship, that should have been the only contentions that
Now
would have
when
been
you
brought
say
to
that
Your Lordship's notice.
some important, new and important piece of an evidence which you gathered, then have you spelled out that when you came to know why you did not come to know at that point of time, and you were the arguing counsel before the appellate court, you should have taken care.
Your Lordship,
Did you not argue?
No, Your Lordship.
What?
Was not the arguing counsel.
Then how can you argue a review? I was going through it.
Yes,
for that reason. How can you argue a review? Are you aware of the Supreme Court
Yes, Your
judgment?
Lordship.
Even our
Yes,
judge.
I'm aware of Your Lordship's judgment.
So, can you? You can't take a new route and then come. Can't. The apex court has come up in a very strong words. If I'm not wrong, it is the AIR 1997 Supreme Court page 1005 or 1005. The apex court has come up very heavily on that you can't engaging a new counsel in the review jurisdiction and then trying to reopen every issues, want to argue, giving a new dimension to the entire case. Supreme Court says it's not permissible. It's not desirable. It does not say permissible, not desirable.
Your Lordship, so we agree. We agree with all the.
We can't. You should have engaged the earlier one who argues.
Your Lordship, the petitioner had tried his best to engage the other counsel.
He has stuck with the review jurisdiction. Yes.
Your Lordship.
Item 14.
Your Lordship, if I may just make one prayer, Your Lordship. Your Lordship, can there be one observation that I may take other appropriate remedies available?
In a review?
No, Your Lordship. In other forums or other appropriate.
In a review, no. And review judgment is not a merger.
Yes, Your Lordship. I'm just seeking
unless it's allowed or reviewed. So you have always a right to.
Yeah.
This is an application for restoration.
Restoration.
Yes, my lord.
When it is dismissed.
Dismissed.
When it is dismissed.
Dismissed on
6/8/2024.
Yes, my lord.
When the restoration application affirmed and filed.
24 is the previous CMFP.
Huh?
6/8/2024. Previously, another CMFP was restoration of the original petition. That has been.
That has been dismissed.
Oh, this is a restoration application of a restoration application. So you want to restore your restoration application by this restoration application.
Yes, my lord.
When this restoration is dismissed, it is 6/8.
Yes, my lord.
And when you affirm this 24 December.
Yes, my lord.
30 days time.
Yes, my lord. Personal difficulty of the.
But 30 days time.
Yes.
Limitation period.
Yes, yes, my lord.
Have you asked for condonation?
I have not filed.
You asked for condonation?
No, my lord. I will file my lordship.
On the prayer of the petitioner adjourned 1 week after.
Item 15.
After vacation.
Please, my lord, condonation of delay 62 days.
Condonation. Have you served?
Ma'am,
Come. Who is he?
Jagannath temple.
Notice.
My lord, may I pray? May I pray? Because this is a eviction issue.
That is a right.
My lord,
Once
short,
the condonation. So
only a short date.
before closer, give it.
Man.
Oh, like-
19th.
Before vacation,
Ma'am.
you immediately file
Ma'am.
by Monday.
Ma'am.
Item 16.
Have you served? Service 2 weeks after.
Pardon me, Lord. That item 14, I have already filed the condonation petition.
Of this petition.
Condonation petition, my lord.
Of this petition.
Limitation. Yes, my lord.
Why you did not?
IA 659 of 2024.
They can find out. Yes. In the meantime, next matter.
Madam.
Just find out.
Item 16.
Madam, when you commit a delay, sir, this with request of respect and humility, because this becomes a very recurring feature everywhere across the country. You will not comply the order. The moment the contempt applications are filed, immediately then challenges to a higher forum are coming with the condemnation of more than a year, sometimes more than 2 years. Can you imagine it? This is 800 means more than nearly 3 years. Nearly 3 years period. Service is make.
Item number 18.
Let us have a glance on order dated 14/8/2025. Kindly have a glance on order dated 14/8/2025. 14/8/2025.
Pass this. No, this is the contempt application, sir.
My lord,
Which order you are saying that it is not, it is violated? Which order?
order dated
29/2/2024.
my lord,
What is the direction?
to pay the wages within 15 days. Thereafter, area mode of petition within a further period of 15 days.
Why
and
you have not
Sir,
made?
there are direction to Sarpanch, concerned Sarpanch has
Sir.
complied. Notice had been to Sarpanch and he has received the notice, noting says. So Sarpanch has to reply on.
So Sarpanch is not here.
No,
Show me that he has received the notice.
my lord, 14/8/2025. On that day, earlier to notice was issued, he is received the.
So where is the service? Service was affected.
Yes.
Oh, let me say that it was affected long back. And the rule of contempt was issued.
Yeah, my lord.
The rule has been served.
My lord.
Where is the service of the rule?
Item delivered. Tracking reports.
Postal tracking report, my lord, says that the item has been delivered to this Sarpanch. Noting says.
Sarpanch is the NS containment number?
6.
6.
My lord.
So who are you? Why you are appearing?
I am not appearing, I am just apprising your lordship
No.
about the development.
Okay.
Yes, please. Yes, ma'am. Yes, ma'am. Yes, ma'am.
No. 14 who was issued? Returnable on 11 September.
No, it is item 18. Next item.
The rule was served before 11 September.
My lord.
There was a 14-8 order, 14th August order.
Yes, ma'am. So then the it was not. And then after that,
No, it was supposed to be filed. The matter? Is there continuation of this application? Oh, that is what I did. Have you served the copy? Anybody is there?
Yes.
Continuation application in item number 14. Record here. Who is appearing?
We would have a copy of nothing, sir.
Please, sir.
Yes.
Next week. Item number 14, order service. Record his name, he appears and seeks for a direction to serve the copy. Yes. The arbitration clause.
Yes, sir. Page number 15, para 11, my lords.
Clause.
Page number 15, para 11. Your lordship has located it.
Very unhappily drafted arbitration agreement. Notice 1 week after, 2 weeks after the reopening of this court following the Christmas.
Item number 2.
Item number 2, my lords, your lordship may kindly have glanced at the arbitration agreement.
Is it the domestic arbitration or international?
It is domestic arbitration, my lords.
Yes.
Page number 16, Article 15.
Page number
16. Article 15, my lords. 15, clause 2. Third line.
Where is the notice under section 21?
Section 21 notice is at page number 51, my lords.
Next.
Item 3.
May I please watch? Also, in the last
Item
opposite
3,
parties,
we're seeking
DHS are
also
trying to
time.
take instructions
My
on the
lord,
acting arbitrator for opposite party, my lord.
Yes,
my
sir.
lord, we have, the department is advised us to suggest the name of the department editor, which cannot be because after amendment, department cannot be appointed. So I seek for more time. In the meanwhile, proper instruction will be received. Non-application mind is given instruction.
1 week after the
Obliged.
the learned DSG to take a yes.
Grateful, my.
Item number 4.
Regarding item number 4, my lord, that financed by Tata Motors Finance.
Sir, where is the arbitration agreement?
My lord,
Where is the arbitration agreement?
agreement is on page number 12, my lord. Annexure
Sir.
2. Annexure 2.
To us that where is the arbitration, I do not find. Is a bill. Is a bill. It is only a bill, invoice, sir.
Invoices.
Where is the agreement? Tell me. Section 11 can only be invoked if there is an arbitral agreement, arbitration agreement. You have not annexed any agreement between the parties.
It has been annexed. It has not been annexed, man.
So
So
dismiss.
I'm dismissed for
What?
better application.
File? File? File memo? If the memo is filed.
Item number 5.
5 that didn't serve the copy of the same, let them serve a copy. Railway general manager, East Coast Railway.
The
So equal to
arbitration
serve.
clause at this contract, Lordship. Lordship, I have flag mark. That is the kind
What is
of
this?
that is a contract that has been back.
Sir, when you come under section 11, then what are the duties of the Chief Justice or his nominee to decide? The first thing is there must be an existence of an arbitration clause, which should be there in the petition.
Let's see that
Secondly
arbitration
thing is
clause.
the nature of the dispute, whether comes within the purview of the arbitration clause, which can only be gone into from the agreement itself. And the other, then third one is that you have invoked that clause, and this is the valid arbitration agreement.
Let's see.
Now, stamp duty has also taken a very important seat in this regard.
Lordship, in the shape of a memo, I have filed the arbitration clause.
Can you? Is it a part of the affirmation? This is decided on the basis of an affirmation.
Lordship, I have about the same in my petition.
Please show us that where you have incorporated the arbitration agreement. Which page? Which page, sir?
Lordship, page 11, Lordship.
11.
Lordship.
Where is that, sir?
Lordship, para 24.
Does it mean
that the petitioner company states that in view of the aforesaid facts and circumstances, it is evident that the conciliation process has failed, and for the purpose of adjudication of.
Are you not understanding the thing, sir? Under the Arbitration and Conciliation Act, I think the first and foremost thing is the arbitration agreement as defined probably under section 7 or 5. 7. Will you not annex the agreement?
Let's see that for that purpose I am.
You are taking me in government. Government is not sacrosanct unless other side is getting an opportunity to deal with.
With due apology, Lordship, I am submitting that contract.
Can it be done? Does it become a part of the affidavit? Because you have to certify that this is what is the original agreement.
That's because it is governed by the contract agreement. That contract. This is the contract agreement. I have.
Where is the contract agreement, sir? Show me from this petition, which runs into 52 pages, or 53 pages. Tell me where is the arbitration agreement?
Lordship, Annexure 1 is the contract agreement.
Yes, show us that it contains an arbitration clause.
Page 16. But that does not define that arbitration clause. But arbitration clause that is defined in.
The agreement may be in the form of a clause. The agreement may be in the form of an exchange of letters. The telex, many things are there under section 7.
For a moment, kindly see my kindly peruse my this recent contract. I have filed.
Can you? Without any affidavit?
With a memo, shape of memo. I have.
Is it? Show me any provision of law that by virtue of this memo, a document can be taken on record.
Lordship, I will file it with an affidavit. Lordship, for the next.
Now I am sitting in a civil jurisdiction.
Lordship, I understand that.
Adjourned till 1 week after vacation.
Item number 6.
They didn't serve the copy of the same. Let them serve
the copy. Yes.
Item number 6.
Yes, sir. Yes, madam.
Lordship, the arbitration clause is on page number 95, read with 96.
Page number?
95, read with page number 96. Page number 95 is the dispute resolution.
Settlement.
Yes, Your Lordship.
The pre-arbitration stage.
Yes, Your Lordship. It's for admission. And the special condition clause at page number 96 details the entire arbitration appointment procedure, Your Lordship.
96 is where is the arbitration clause?
So page number 95, Your Lordship, page number 95.
95.
Clause 8. Clause 8, settlement of disputes. Clause 8.2, dispute settlement. At the end of the page, Your Lordship.
No, in the special conditions of contract,
Yes,
is there any clause for arbitration?
Yes, Your
Please
Lordship.
tell me.
So sorry, Your Lordship. It's page number 98, Your Lordship. Page number 98.
Where is a letter under section 21?
Lordship, it's annexure 6, Your Lordship. That is page number 146 to 147.
Claim in respect of what period?
Lordship, delayed payment, Your Lordship.
What period? What is the last invoice of the
Lordship, the last invoice was sent on 14th August 2023, Your Lordship. 144, 145. Page number 144, 145, Your Lordship.
140?
145. We had sent a 30 days notice for amicable settlement as well.
But what about the claim for what period?
Lordship.
Just to ascertain a time barred claim or what?
The invoice. Lordship, the invoice has not been attached with this petition, Your Lordship.
Have you made any amendments?
Yes, Your Lordship. On page number 4, para number 5, Your Lordship. Lordship, the agreement was abruptly closed on 30th September of 2022. Suppose that, Your Lordship, a final invoice was raised.
Have you served the notice?
Yes, Your Lordship.
In these matters, we have not received the copy.
No, Your Lordship, not in these.
Notice 2 weeks after the notice.
Both the cases.
Both the cases.
Yes.
Item number 7.
Yeah, please. On page 29, clause 17 is the arbitration clause.
The dispute amongst between the partners.
Between the partner. The legal exclusion of this petition as well. Annexure 2 is
Where is the invocation of the arbitration agreement? I mean, section 21 notice.
33, page 33.
Page
33. Annexure 2. With the notice I have served.
The 10 partners, you have been excluded, each one. You're not being paid the remuneration, the whatever the monthly charges. Notice 2 weeks after.
Item number 8.
My lords, item number 8, 9 are connected matters, my lords, arising out of the same project, but with respect to different packages. This is for appointment of a substitute arbitrator, my lords, because the learned arbitrator who was conducting the arbitration unfortunately passed away.
Which for the other side?
Ms. Rath is appearing.
Can you unmute your system, Ms. Rod?
Lordships, I have, we have instructions to appear.
Yes. So what is there? There was already an appointment of an arbitrator. No,
There was, and I think they had filed an application in the lower court for that.
What the lower court will do?
Yeah, no, I'm just saying about the history of the matter, and I think that the company went into liquidation, if I'm correct.
No, my lords. May I place the correct facts?
Under IBC or what?
No, my lords. My lords, this company went under IBC on 8th of May 2018.
Any resolution?
Yes, my lords. And it was approved on 11th of June 2024.
Yes.
On 11th of June, it was resolved. Thereafter, the new management came into place. And after the new management came into place, they got the files, etc. of this matter and later realized that this arbitration was never continued by the learned RP. But the RP had actually written a letter to the other side.
I am just asking, the new management has came after the resolution professor was appointed and the COC has approved the resolution plan or what?
Yes, my lords. The COC has approved it. The learned adjudicating authority has approved it on 11th of June 2024. I placed the order on record.
Madam, what is the difficulty?
Lordships, I'll have to file a proper counter.
You have to file nothing. You just wanted to prolong.
Lordships, we've just been informed today by NALCO to just appear in case the notice goes, and we'll have to.
Keep it in the next week. I will take up to take instruction in the.
Grateful. Item 9, my lords, also same thing.
Yes, both the matters.
Well, item number
Ms. Roth, who appeared for the opposite party, to take an.
number 10.
Lordship, this matter actually, there is no arbitration agreement, Your Lordship. I'll be right away. I'll be honest about it.
Then why section 11?
Lordship, we are coming under section 11(6)(c), read with section 18(3).
What?
18(3) of the MSMED Act, Your Lordship. Lordship, what has happened is we submitted a reference. We submitted a reference to the MSME Facilitation Council. However, it was not initiated for quite a long period, Your Lordship, for in fact for 2 years. The reference, there was no settlement that was initiated. So, Your Lordship, if you see section 18.
How 11(6)(c) applies?
Lordship, Lordship, there are available judgments as well. Where the Lordship, as you can see, Your Lordship, the 11(6)(c) clause says that a person, including an institution, Your Lordship.
Madam, can you read a statutory provision without reading the very first line of the section?
Your Lordship, where subsection C says that where under an appointment procedure agreed upon by the parties, Then the subclauses follow.
Again, that what is the meaning of the appointment procedure,
Procedure
agreed
upon by parties.
means what?
Lordship.
What does it mean?
Very well, Your Lordship. I agree with your point, Your Lordship. However, if you see, Your Lordship, the available judgments of the Bombay and the Delhi High Court, Your Lordship, the High Courts have endorsed this view that when an application is filed under 11(6)(c), and where the Facilitation Council fails to mediate, as contemplated in Section 18(3), pursuant to which the council is required to refer to the dispute to the arbitration. In such cases, Your Lordship, the provisions of the 1996 Act shall apply to such dispute as if, Your Lordship, as if the arbitration was in pursuance of an arbitration agreement referred to in Section 7(1) of the 1996 Act, Your Lordship.
Then under what circumstances?
Your Lordship, the circumstances are...
When there is no arbitration agreement agreed upon by the parties.
Lordship.
And therefore, tell me with how far this shows the judgment.
Lordship, as you can see, Your Lordship, in subsection 3, when the conciliations, subsection 3 of Section 18 of the MSMED Act, where the conciliation, Your Lordship, stands unsuccessful or terminated for any cause, Your Lordship, then there is a statutory arbitration requirement.
I know I'm concerned. That's why I'm...
Yes, Your Lordship. Section 18, subsection 3, Your Lordship. Where the conciliation initiated under subsection 2 is not successful. Here, Your Lordship, it's...
Section 18.
18, subsection 3.
Which you're talking about
MSMED
Act of 2006.
Yes, Your Lordship. Micro small enterprises.
Of 2006.
Yes, Your Lordship.
What you are reading is not there in this book. That's why I'm asking. Look at the book, section 18. 3 does not. You are reading 4 or 5? I do not.
3, Your Lordship. Your Lordship, actually, as you can see in the footnote, Your Lordship, Mediation Act of 2023 had... yes, Your Lordship.
What is the footnote?
But it wasn't...
An author.
It wasn't...
It's a statute, I'm asking you.
Lordship, Mediation Act actually wasn't in force.
Till date, it has not been enforced.
Your Lordship.
It has not been enforced. There is only 3 provisions of the Mediation
Yes,
Act
Your Lordship.
has been put
Your Lordship.
put in action.
Yes, Your
Even
Lordship.
a council has not been constituted as of.
Yes, Your Lordship. So
what?
So, Your Lordship, we were relying on this previous provision, Your Lordship.
How can it be?
Lordship.
That's a commentary of an author. That's his perception about it.
Yes, Your Lordship.
It does not partake a character of a statute. The statute is there, what is there in the section.
Yes, Your Lordship. Your Lordship, because the date of enforcement is still to be notified, Your Lordship,
but still the mediation under section 89 of the CPC is always active. May not be a mediation act of 2003.
Lordship.
What is the significant difference between a mediation act and this? The significant difference is one, very laudable one, is that its enforceability till now is an agreement. But by virtue of Mediation Act, if it comes into force, it will partake a character of an award and can be enforced and executed like a decree of the civil court. Can't take advantage. But the mediation is still there. There is no difficulty.
Lordship, there is one change of circumstance. While we have listed this application, Your Lordship, the mediation has initiated in November. We had filed this application in October. Till then, for 2 years, the mediation hadn't started.
Then it is premature.
Lordship.
What to do then?
Whatever Lordship seems fit in this situation, Your Lordship, because in November only the conciliation has started.
We have to discuss as premature or...
Lordship, otherwise I'll withdraw the case at this juncture and seek your liberty to...
File a memo.
Lordship. Grateful.
Item 11.
It's a fresh matter, my lord. I am from virtual mode, my lord. The page 9, clause 51, the arbitration clause, my lord. Arbitration clause is 51, clause 51 at page 9.
This is something very unique, that the contract is annexed to the writ petition in a very segregated or in a very suitable manner, which suited the petitioner. Sir, will you not include the full copy of the agreement? One page.
The
arbitration
arbitration clause.
The nature of the contract. We do not know the nature of the contract. We do not know what are the terms and conditions embodied in the contract. How the dispute has arisen. We do not know. Simply, it will not do.
I'll file a total contract.
It is granted to the petitioner to file an affidavit.
Agreement.
Say page.
Page 31 is the relevant clause of the agreement. The entire agreement is before lordships. Page 31, the arbitration clause.
What is the nature of the agreement?
So the nature of the license, it was to run a hospital at Bhubaneswar for a period of 15 years. That the agreement was there. Before that starts at page 27.
Agreement?
Yes, sir.
The license.
Yes, sir. Then and license, sir. And the clause was 15 years, and whatever terms and it was a license.
Not a lease.
No, it's a license. So then, sir, during that period, it was stated that if the license is terminated within a period of before 15 years, then because as your lordship knows, the hospital running it's Ashwini Hospital in Cuttack and Hospital in Bhubaneswar, and it's very capital intensive. And it said that if there is cancelled within a certain period, then they would compensate us in this amount.
Where is that?
That is there, sir. Before lordships kindly see page 29A. Roman 3 in down below, clause 4. If a lordship get it. Roman 4. Licenses shall pay, if a lordship get it.
Equivalent to 25% of the amount
Yes.
invested by the licensee.
Yes, sir. Because it's very capital intensive. Everything is expensive, and if you terminate it for 15 years,
they are terminated.
They are terminated, and that's the reason it's a clause. And that's
What is the date of the agreement?
The date of the agreement is 2019.
And 15 years.
15 years. Yes, yes. If it is within 5 years, sir, then it will be 50%. It is now 6 years. 34. It is 6 years. On the 6th year, they terminated. So they had to compensate us 25%, which have not done for
Have
which.
you intimated to them that what is the cost?
Yes, sir. Yes, sir. We have issued notice. Sir. We have intimated, we have issued notice, and we have given section 21 notice because it was also three arbitrators were to be appointed. We have appointed an arbitrator and asked him to appoint. And what he says, they have refused and they have said that your claim may be bona fide, but this is not the forum. That they say.
This is not a forum.
This is not the forum. What they say. Then they say everywhere, sir, it's not a forum. If lordship get it, sir. whatever. Kindly see, sir, page 113, the reply.
Then what is the meaning of the word incidental to the license or anything matter mentioned in the license?
Everything is coming under the license. But what they say, sir, that since you have undertaken the indemnity, sir, 113 were referring, sir. Last part, 4-5 lines. That since you have undertaken to indemnify the licensor and the above matter,
113.
113.
Yes.
Last 5 lines. That
Last
since
5 lines.
yes, sir. Since you have undertaken to indemnify the license and above matter, even if it is a legitimate demand, then you can resort to invoke arbitration. Then you cannot resort to the arbitration clause of the license agreement with the liberty to choose the appropriate forum for adjudication also.
That's an admission of a dispute.
A dispute is admitted, but what they say that this is not the forum.
And there is an
Cover notice.
Yes, sir.
1 week after.
Grateful, sir.
Item 13.
Running page number 26. Running page number 26.
Yes, sir.
Clause number 9 is the arbitration clause. This dispute is regarding delayed payment and non-payment of my legitimate dues.
This is delayed payment
Mileage.
or non-payment.
Non-payment mileage.
When the invoice was raised.
Mileage and annexure 2, page number 28, 30/11/2023. 30/11/2023 mileage.
Where is section 21 notice?
Mileage in annexure 8, page number 67 and 68.
For supply of the goods.
Mileage.
Is for supply
No,
of the goods.
that was a work order to clean the sewage lines of the honorable
It's
town.
a service contract.
Mileage.
Service.
Grateful.
2 weeks after.
Item 14.
Please, your lordships, minutes. Annexure 1 at page 18 is the purchase order, my lords, which was issued by the present petitioner, my lords. And if your lordship sees, that is dated 8/6/2024. That was for execution of a, my lord, civil works pertaining to a blast furnace, my lords. Now, if your lordship sees page number 24 of that agreement, running page 24 minutes, that contains the arbitration clause.
Yes.
My lords, at the bottom portion, my lords, there is a heading, arbitration.
This copy is the email or what?
No, my lords, it contains the arbitration clause, my lords.
Sir, there must be a duly valid contract which should be entered into. I do not find.
This is a purchase order, my lords. This is a
page.
At page number 18.
Yes.
Yes.
No, I got it. That
Yes.
page number 18 is the purchase order.
Yes, my
You
lords.
are talking about an agreement.
Yes, agreement was.
This purchase order contains the agreement
No,
clauses.
that succeeds the agreement, my lords. That is pursuant to an agreement, and that contains the arbitration clause, my lords.
Where I do not find from here at page 18. If you go, I understand that they have said. Then this definition is the owner.
Yes.
So it's a service order.
Yes.
So I'm just saying in the form of an order, these terms and conditions are embodied in it.
The other terms and conditions, everything is contained in manual. How the work is to be carried out, how the bills are to be paid.
What is the heading of this page 18?
Well, a service order,
Right.
my lords.
So this is an order which they have placed upon you.
Yes.
That's a service order.
My lords.
If they have placed, then I am asking you because This is unheard of. I have not come across this kind of an agreement which is not signed by the parties, which does not contain the clauses. I am simply asking you whether these I would say the content is a continuation of a service order, or that at the bottom of the service order these are incorporated. I am just asking you this because I get this notion from page 18 bottom.
My lord. That in the middle portion, my lord, there is this purchase order number is mentioned, purchase order date is mentioned, the validity period of this agreement is mentioned, and the nature of job.
I understand, but when you are invoking an arbitration jurisdiction,
My lord.
then the first and foremost thing is that the parties must have decided or agreed to settle their dispute through arbitration. I am just trying to decipher if the parties have agreed, then there must be either an agreement or by way of a clause or by way of anything, the correspondences as envisaged in section 7 of the arbitration and conciliation. I just wanted to know because this is something which is.
If there was any agreement per se, my lords, between the parties preceding this purchase order, my lords,
Where is that?
No, that I have, that is not there, my lords. That is not from.
Then
I,
so from where? Because it is not neither signed by the parties. You are aware that the court, while appointing the arbitrator, will see many things.
My lords.
There is a valid agreement.
I'll file it with an additional affidavit, my lords, because
supplementary affidavit. 2 weeks.
Well,
item number 15.
In my lord, page number 14, clause 24 is the arbitration clause, my lord. Page number 14, 24, my lord. For not.
Yes, page 14.
My lord. 24 clause.
So have you approached them for amicable negotiation?
My lord. Well, annexer last is annexer 5. Earlier annexer 3, page 34 to 43 is there. Letter. Annexer 3 series. Page 34 to 43 is there. Last is annexer 5, page 52, my lord.
What is this page 39?
39, this is the work order done by 4 area.
I can't read it, sir.
My lord, this is the Odia. My lord, the 4 project were this water storage work in the area of Bhubaneswar, my lord. I have, that was para 4 have written in English, my lord. Para 4 of my petition, my lord. Execution of sewage network work, page 3, para 4, my lord. Sewage work in 4 Bhubaneswar area, my lord.
Then where is the section 21 notice?
Dear notice last page 52 annexer file, my lord.
Sir, your claim was there in 2020.
My lord,
Your claim was there in 2020.
claim is you are.
Then the limitation will come into play.
My lord.
What by limitation? Your right accrued in 2020,
My lord.
particularly on 9/1/2020. Now we are in 2025, hopelessly barred by limitation.
I will file a limitation petition, my lord. I will file next year.
What?
Limit.
Section 11, the Section 5 applies. Or for recovery of the amount, if a suit is to be filed, the Section 5 will apply. What are you talking about?
Well,
your claim has become time barred. How can then we appoint an arbitrator? Apparently time barred.
my lord, poor lady are approaching before the authority, but you cannot.
But whatever approaches, there
my
is
lord.
a clause which says that within 30 days, if there is no negotiation which has happened, you can go for arbitration. So you could have gone in arbitration in 2020 or 21 or 22 at best. But you are coming in 2025, writing a letter when it is already hopelessly barred. What to do, sir?
Let's give liberty to approach again. My lord.
What are you talking?
My lord, the poor ladies.
Approach again for same fate. Further delay.
My lord.
So, when it has become a time bar, then how can you do it? No, sir, I can't. I can't issue a notice. Sorry.
Second arbitration application we have filed with a prayer to appoint a substitute arbitrator under section 15 clause 2, your lordship, read with section 11.6. Arising out of the memorandum of agreement dated at annexure 10, page 43, your lordship, running page 43. Thereafter, the arbitration clause is at page number 48, clause 12.
What is the latest view on this subject, section 15.2?
Gotcha. Section 15.2. Termination of mandate and substitution of arbitrator.
You know,
In addition to the circumstances referred to in section.
there are two things. First thing is where the arbitrator withdraws from office for any reason.
Yes, Your Lordship.
So must we say that I am unable to continue.
Yes, Your Lordship.
Or parties by their consent, they can agree.
Lordship. Your Lordship, in this case, the previous arbitrator was appointed as per the directions of this Honorable Court, and the previous arbitrator has also sent a letter communication at page number 15, Your Lordship. Due to some personal reasons, he could not be able to appear. Page number 15 and annexure 2, Your Lordship.
Annexure?
Annexure 2, page 15.
Oh.
Annexure.
Service 2 weeks after.
Item note 17.
Sure. Lordship, this is an application for
Substitute.
sick. Yes, Your Lordship.
Have you
In this
sent the other
connection,
side?
copy serve.
My lord, 17, my lord, I am opposing, my lord. I appear on behalf of the respondent.
Opposing.
Opposing, my lord.
So tell us that why you oppose.
My lord, the domain teacher itself is an application which has been taken as an IA in furtherance of our disposed section 11 application, my lord.
The procedure is a handmaid of justice. Can we not convert it into a regular?
My lord, I must be candid before your lordship. To my reading of the provisions of the act, my lord, the only provision which enables your lordship to further give an appointment is under 15.2 read with 11.6. However, my lord, that has to be a separate proceeding, and I'll cite a law on this regard.
That is simply a procedural aspect.
My lord,
That's why I'm reminding you of the celebrated constitution bench decision of Judge Ram's case.
My lord,
I would have said that the procedure is a handmaid of justice.
My lord, so far as the statute is concerned, my lord,
procedural aspect, how the petition has to be registered as an independent application or as an interlocutory application, how it materials. Tell me on a merit that when you oppose, what are the grounds to oppose?
my lord, the penultimate ground of oppose is, my lord, what culminates in this thing, the arbitrator is recused, and that is in furtherance of an application taken out at behest of the claimant before the arbitrator. It's not even an application; it's a one-page letter, my lord. My lord, moreover, prior to that letter, the petitioner has approached the Commercial Court Bhubaneswar by filing a Section 14 application. At the same point in time, they have also sought for an extension and filed an application under.
Oppose when Section 11 application was allowed.
My lord, I am not opposing on the appointment of the arbitrator. I want the same arbitrator to continue, my lord, because the reason.
Up to him, if the arbitrator says that I do not want to continue, I want to resign and resign from there. Can you force anybody to continue?
My lord, I am not forcing, my lord. I am only assisting your lordship.
Up to his wisdom. Had it been a case that he is coming up and making allegation against the arbitrator or whatever, the arbitrator is still continuing, I can very well appreciate what you say. But once the arbitrator has taken a conscious decision that I do not want to continue, I want to resign or withdraw my offer or myself from the arbitration, then what more? It is his decision. You cannot compel him to do something against his wish.
My lord, may I appraise your lordship on the factual background, my lord?
What is the fact? I appreciate that they made an allegation against the arbitrator that should not have been done, whatever is the reason. But ultimately, the arbitrator has withdrawn himself.
My
So
lord,
I don't want to continue with the arbitration. What more?
My lord, the arbitrator has withdrawn not for any reasons which has compelled him on the ground of biasness, my lord. It's simple. There is a representation where we have not been afforded with an opportunity to place our case, my lord.
What? You will oppose that application and arbitrator will decide whether he will withdraw or he will not withdraw.
My lord, kindly see the content of that letter, my lord.
Interesting proposition. I'm really very delighted and overwhelmed to hear you on this proposition.
My lord, kindly see the content of the letter, my lord, which has been gone.
Maybe this letter is not appropriate. I accept. There is no difficulty. I appreciate what you say, but ultimately it is within the arbitrator. Under section 16 also he can decide whether to continue or not to continue jurisdiction. If he has taken a conscious decision that I do not want to continue with the arbitration, I want to withdraw, does it not bring the situation under section 15? Tell me.
My lord,
irrespective of what has happened.
15.2 law.
My lord, that is where I join issues, my lord. My lord, unless my first point of argument, first limb of argument is, my lord, if the application has not been accompanied in the provisions of section 15.2, then, my lord, I ask this question to myself whether your lordship has the jurisdiction to pass an order for a fresh arbitrator, my lord.
Again, I am saying there is no procedure which is provided.
Gotcha.
My lord, in this regard, if your lordship is kind enough to consider.
According to the rules that are applicable to appointment of this. So I will treat this as an application under section 11. No difficult. It's simply another get up or a dressing which is to be done. It will have the same effect. Yes, do one thing. This application has been registered as an I
file an affidavit, my lord.
What affidavit? For what?
My lord, only to bring on the conducts of the petitioner, my lord, how the arbitration.
Does it have any impact on consideration under section 15? You may come. You may come in.
My lord, if that liberty, if your lordship be pleased to grant that liberty, my lord.
Oh no, that liberty is always there. Can we deny you to file an affidavit? File it in the meantime. We are keeping it on next Friday. Do it in the meantime. Come.
I will.
Consider.
Item 19.
My lord. My lord, there was an order on 9th May.
19 for the opposite party, my lord, and if the lordship permit me, I am filing to objection of this arbitration of section 11 of the arbitration act. Today I am filing the objection to this petition,
Fine.
and I am also serving a copy. And
Please, you have a right to file, no doubt. Right.
I have also served a copy.
Please.
Just no one.
Would you like to file rejoinder?
My lord.
My lord, one line I need to submit, my lord. This is a completely time-bound application for this appointment.
You have taken this plea. We'll consider it.
And one more thing, that is MOU has lost its existence since it was for 2 years. It has been made in 7/9/2018. It had lost its existence in 7/9/2020, my lord. I have written all these things.
Sixteenth.
Yes.
Item number 20.
In this case, I have instruction to appear in this case, my lord, for opposite party. I have also filed the Bhokilat Rama today before the registry.
Plus, I am for the petitioner, Milots here. Milots, the respondent also, by implication, Milots, they have also admitted to go for arbitration. Milots, they have also suggested some names. If it is for Milots, if they want to file reply, Milots, I cannot think. But in principle,
What is your prayer? You have filed Bhokilat Rama today.
Yes,
So
my
that
lord.
accepted.
I pray 2 weeks time to file counter, man.
How much?
I pray 2 weeks time to file counter, man.
Record his name appears for the opposite. It is over. Yes. Okay. Yes. Yes, go on.
Item in the special list, item number 1, CMP 1595 of 2020.
Madam, pursuant to your lordship's order, the notice has been issued, but it is noted that both the notices return unsought. The address here absent.
Left. Then you have to. You have given the same address which is given in the suit.
Yes, madam. Same address.
Are they represented by any counsel there?
They are the plaintiff there in the court below.
Oh, so they must be represented by an advocate. Can you serve the copy on him?
They are the Khordha.
Just to expedite.
That's the Khordha. And may I play
Khordha is
one
not
thing,
far
madam?
out. Well, tell your client to go and serve. He's contesting the.
Well, simple is the prayer to direct the Lord of Civil Court dispose of my petition. That is the whole prayer in the CMP.
I understand, sir, but the difficulty I noticed on the other day.
Yes, ma'am.
Is something else.
No, madam.
Their presence is required.
My
my simple prayer is to direct the learned civil judge Srinidhi Khorda to dispose of my petition. That is the whole prayer.
Sir, we do not know whether this petition has been filed just to
Seeking for a direction only, man.
Procrastinate the litigation. There is already an order which directed the other application to be disposed of first. All these things have to be looked into.
But here, that has not been decided by the learned trial court.
What is this application which you have filed?
My application is under Order 711, that is to be decided there.
Correct.
But irrespective of argument, the learned trial court is not disposing my application. That is the prayer in the
Order 711.
Yes, madam.
That is what you wanted a disposal.
Yes, madam.
When is the last or when is the next date fixed?
Madam, the date has not been fixed since long.
What are you talking about? There cannot be any undated record.
Madam, the learned trial court is adjourned the matter without any reason.
So that is what I'm saying. When he is adjourning the matter, what is the next date fixed?
Madam, I have not taken instruction.
So say
the last order which I filed.
That has gone more than 1 year.
My lord.
It was fixed on the 18/7.
My lord.
So what has happened after 18/7?
Well, no order has yet been passed. It's my instruction today morning, madam.
On 18/7, there should be a record.
Yes,
he has adjourned for a further date. I just wanted that date, sir.
I'll take instruction. Let it come next week.
Last time I told you to take instruction. You could have taken over the telephone. Your counterpart there.
Yes, ma'am. I'll take that instruction.
Unnecessarily, you are delaying the disposal of this. Let us see. This is an application under Article 47 of the Constitution of India seeking a
My lord, similar matter out.
Requisites have not been filed.
Yes, my lord.
There was a direction.
To that effect, my lord, a similar matter was filed. So the copy.
I am asking you why you will not file a requisites when
Yes,
there
my
was
lord.
a direction.
To that effect, my lord, a similar matter was filed by the present opposite parties, being a petitioner.
So you chose to defy the order of the
And
court,
then
not necessarily. I will not put in the requisites. What's the necessity of applying the order of the court?
I humbly apologize to that
It's the
effect.
meaningless one.
No, my lord, I have already served the copy on the council for the present opposite parties. My.
He's not appearing. How do we know?
My lord, I have a memo to that
Maybe
effect also.
he may have an instruction somewhere else, may not.
Lord, because
he has not come up with the Vagalatama in this case. So the notice has to be gone into.
Then, my lord, I'll file requisites. This similar.
Either you secure his presence. If he waives, no problem. Secure his presence.
Yes.
Call it.
Yes, my lord.
Pass over.
Item number 3.
Here in one additional evidence application was filed in appeal. That
Have
has
you
been
filed the requisites?
Yes, notice is sufficient.
Service affected?
Yes, and it appears in the tracking report says.
What is the impugned order?
Impugned order is an application on Order 41 Rule 27 CPC for additional evidence that has been disposed of in isolation without disposing of the same in appeal.
The judgment of the Supreme Court.
Two judgments of the Supreme Court have been referred. Many are there. 2012 and 2015 have been referred to in this judgment of this honorable. The Supreme Court's judgment has been quoted also. In paragraph 9, it has been quoted, the Supreme Court judgment.
My lord, in this case, your lordship at least to issue notice. The noting is that AD has not been returned, but the tracking report said the notices have already been delivered. But nobody has appeared. So your
What is
lordship. And
nature
the
of-
plaintiffs
It's a
have
first
filed.
appeal.
Plaintiffs have filed a suit for declaration of easementary right.
Easementary right.
Yeah, and also filed an application for injunction. The learned trial court, after hearing both the parties, instead of granting injunction, passed an order of status quo, saying that everything can be gone into the trial. The learned appellate court set aside that order, saying that there is an alternative way. But the alternative way which has been pointed out is one is a government land, Patito land, and another belongs to another party. So, your lordship is pleased to issue notice on that.
Now what to do? 1st December. So they come in the next week. It is delivered on 1st December. So time
Yes,
is
yes,
very
my
short.
lord. Yes,
Time is very short.
yes, ma'am.
Next week.
Item number 5.
Notices has been issued.
You are appearing for the other
Yeah,
side.
only yesterday I have appeared. So, my lord, the matter may come next week.
Next week.
Interim application is there to stay away because in the meantime, during pendency, pre-evidence has been adduced from the side of the plaintiff.
What is the application? Nature of the application? We are keeping it in the next week. It is
My
not
lord,
going to happen.
next week, my
No difficulties.
my-
Yes. What?
Item number 2. Item number 2.
I am not able to secure his presence.
So next week you secure his presence. We'll see to it.
My lord, just
Otherwise, you put in the requisites.
I'll put in the requisites. Just one knowledge.
No, one. Either you secure his presence, we will wait, or you put in the security, the requisites, we will
Well, that's
extend the time.
similar matter is pending before the coordinate bench. That is what I'm trying to convey.
What? How can it be pending before the coordinate bench?
If it is before the regular bench, my lord, 2025 CMP. It is to be listed on 10th of December
I do
2025.
not know, but this matter is next week. I will see to it. We'll see when it matter.